Good morning, everyone. It's wonderful to be with you, all of you, for today's event. My name is Neera Tandon, and I'm president of the Center for American Progress. On behalf of CAP, I just want to welcome all of you, and in particular, I want to welcome our panelists, Caroline Fredrickson, Jamal Greene, and Gabe Roth. I know Maggie will go into more detail about their backgrounds and their unique perspective in a minute, but I want to thank them all for taking the time to be with us for this really important event and for all the work they do to raise awareness about the impact of the Supreme Court and the importance of Supreme Court reform. Chief among the work is the need to implement term limits on Supreme Court justices. The court in 2020 operates in a vastly different world to the one that existed when it first convened in the 1700s, and yet the rules from when it was established largely remain completely intact. Where many of the Supreme Court justices in the first 50 years of the court's existence served for less than 15 years, it's become routine for members of the court to now serve for decades. The average term for a Supreme Court justice is now longer than it's been at any other point in our nation's history. This has led to less regular vacancies and an ever-increasing focus on the political stakes involved. You need to look no further for an example than the political sideshow that took place in the wake of Justice Scalia's death, when Senator McConnell kept the Senate from even considering President Obama's nominee. A year later, he then jammed through now Justice Gorsuch's nomination by eliminating the filibuster for Supreme Court nominees. That is a tribute to the stakes and the looming legitimacy crisis that the federal judiciary is facing. Supreme Court term limits can help provide a solution to that. Regular appointments would put less intense pressure on each individual pick and would remove the randomness of the judicial selection process. If each presidential term brought a set expected number of justices, then elections, and not happenstance, would inform the makeup of the court. It's a common sense reform, and that one that would ensure the court is more reflective of the country as a whole. I know the panel will discuss this in more detail, and I'm very excited for that discussion. And now it's my absolute pleasure to turn it over to Maggie J. Buchanan, CAP's Director of Legal Progress, who will be moderating today's event. Maggie?
Thanks so much, Neera. Everyone, thank you again for joining us this morning. My name is Maggie Jo Buchanan, and I am the Center's Director of Legal Progress. Yesterday, we released a new issue brief on term limits for the Supreme Court, and I am honored to be moderating today's discussion. After our panel discussion concludes, we have set aside time for questions from the audience and hope you all will participate. But before I introduce our panel, a few brief housekeeping items. First off, live captioning is available at americanprogress.org/live captioning. In addition, as I mentioned, we have set aside time for questions. Please feel free to submit any you may have using the questions tab on the side of your screen or on Twitter using #SCOTUSTermLimits. And finally, as I'm sure many of you are aware, we're experiencing a little bit of weather here in DC. Hopefully we won't have any technical issues as a result, but please have patience, but I think we'll get through this just fine. Now to introduce our panel. First, Caroline Fredrickson is a senior fellow with the Brennan Center and distinguished visitor from practice at Georgetown Law. She served as the president of the American Constitution Society from 2009 to 2019. In those 10 years, she helped grow ACS into an organization with lawyer chapters across the country and student chapters in nearly every law school in the United States. Caroline has published on a rich variety of legal and constitutional issues and regularly contributes opinion pieces for outlets such as the New York Times and the Washington Post. She has also authored several books, including her most recent, published this year, The AOC Way. Thank you for joining us. Next, we have Professor Jamal Greene. Jamal is the Dwight Professor of Law at Columbia Law School and a widely recognized constitutional law expert. He has written in depth about the Supreme Court, about constitutional rights adjudication, and about the constitutional theory of originalism. In addition to his many notable academic writings, his articles have appeared in the New York Times, Slate, New York Daily News, and the Los Angeles Times. In 2019, he served as an aide to Senator Kamala Harris during the Senate confirmation hearings of Justice Brett Kavanaugh. His forthcoming book, How Rights Went Wrong, Why Our Obsession with Rights is Tearing America Apart, will be published next year and examine how and why we need to recouple rights with justice. Finally, last but not least, Gabe Roth. Gabe Roth is the executive director of Fix the Court, a national nonpartisan organization that advocates for non-ideological fixes that would make the federal courts, and primarily the US Supreme Court, more open and more accountable to the American people. His organization has worked with individuals and organizations across the country and across the political spectrum. They have co-hosted events with the Federalist Society and the American Constitution Society alike, as well as more than a dozen law schools. Gabe is sought after by the media, providing commentary to policy-focused podcasts, as well as regular general appearances in the press. Previously, Gabe managed the Coalition for Court Transparency, a national alliance of media and legal organizations that advocated for the broadcast of Supreme Court proceedings, among many other issues. All, thank you so much for joining us this morning. Just to jump right in, we thought it could be helpful to ground this morning's conversation by exploring how the position of a justice has actually changed since the establishment of the court in the late 1700s. And Caroline, if you wouldn't mind kicking us off, how has the substance of that role changed over the years?
Well, you know, it's a very interesting question. I think there are a lot of ways that it's changed. I mean, for one thing, the power of judicial review has become pretty all-encompassing. The idea that the Supreme Court is the last arbiter on so many questions that are fundamental to our society right now. We're seeing right now it playing out as communities are struggling to deal with elections and trying to, in the middle of a pandemic, and adopting new rules that might enable them to do a better job, and finding the court preventing them from doing such a thing. So the impact on our elections, on a whole variety of issues that are so central to our lives, that I think was not foreseen when the Constitution was drafted. The Supreme Court was never seen to be so powerful. And as the Supreme Court has become more powerful, and the cases that they take are more significant in terms of the reach and their impact on American lives, the justices themselves are serving longer and longer periods of time, and so aggregating so much power to themselves, unreviewable power when it's a constitutional question. And the way that the court is structured now, they're detached from the generations that are in power in politics now, or are coming into power. They represent prior administrations, or they represent prior views that thereby are allowed to entrench approaches to our politics and to our vision of what the Constitution is for decades longer than people might agree with that point of view. So I think it's to a great extent, it's about the real deep power that the Supreme Court has, unreviewable power, a power that stretches into all aspects of our lives. But now, as we see, you know, as we approach this most significant year, perhaps in American history, with this election that's coming up, with this pandemic, with the incredible economic dislocation, it is a fundamental question whether 9 unelected people should be able to have such an impact on where this country goes.
Thank you. Yeah, long are the days of circuit riding and Supreme Court justices operating without clerks that we saw in the earliest decades of the country. Gabe, and just to make sure to draw out something both Caroline and Nira actually mentioned, would you mind just speaking to how the average length of time each justice sits on the court has changed?
Sure. So up until the presidency of Richard Nixon, the average justice served about 15 years. Since then, the average justice has served about 28 years. That number is growing. Justices like who've left the court recently have served close to 30 years. Scalia served about 30 years. Kennedy served, I think, 29 years. Stevens 35. Rehnquist 33. And so that's becoming more common due to everything from the prevalence of gaming out your retirement. So someone who's sitting in the Oval Office tends to agree with you and waiting for and hanging on to your jobs until that happens, to advances in health and well-being that just didn't exist even a generation ago. So that's definitely something that's spoken about a lot. And one of the things that I like about this conversation and most term limits proposals is that we're saying that shouldn't be tenable on the one hand, but on the other hand, we're not generally advocating, and I know we'll talk about more specific proposals in a bit, but we're not generally advocating for any sort of reduced amount of judicial independence, right? Everyone who thinks about this topic realizes that there should be, I mean, except the people who post on the Fix the Court Facebook site who think that there should be like elections every 4 years for justices or whatever. You know, kick all the bunks out now. But, you know, that aside, you know, people who are serious about this think about it in a way that, you know, you want to have a proposal that balances the need for ending superannuation with the need for independence. So I think that, you know, as we get into this discussion, it's important to home in on the fact that you can do both at the same time, maintain independence and ensure that justices aren't serving for 40 years.
Great. Now, and sort of tying this together, Jamal, can you speak a little bit to how the nature of confirmation hearings have changed, particularly over the last several years?
Sure. They've changed quite a lot. I think a lot of us know that, but it may not be quite as obvious as the degree to which it's changed. If you look over the long history of Supreme Court confirmation processes, most Supreme Court justices have been confirmed either by a voice vote, so without counting the individual votes, or by a large supermajority. And there have been, you know, throughout history, there have been super partisan confirmation processes. If you look at the Andrew Jackson's efforts to pick Supreme Court justices, or Louis Brandeis or Thurgood Marshall, but not until recent years has this been sort of a regular partisan theater where there's lots and lots of heat and lots and lots of people getting really angry, but not a lot of light. So we actually don't learn that much about the nominees, even though it's become this kind of partisan sideshow. And I think that's itself not especially heartening or productive. 4 of the last 5 nominees have failed to get 2/3 vote. The last 3 were pretty close to straight party line votes. And then, of course, as Neera mentioned at the beginning of the call, the replacement of Justice Scalia has really upped the ante. So the Senate's refusal to fill that seat with Justice Garland, or to even give him any process at all. And I think from now on, we should expect the Senate to regularly not take up the nominee of a president from a different political party than the Senate majority. And over the last 52 years, we haven't had a Democratic majority on the Supreme Court, even though Democrats have had the presidency for 16 of the last 28 years, and have won the popular vote in all but one of the presidential elections in the last 32 years. So that's not a lot of accountability on the court. I think a big part of the reason for the change in the confirmation process has to do with something that Caroline mentioned, the change in the nature of the court's docket, so that the rights revolution of the 1960s, where the court is involved in criminal justice issues and equality issues and civil liberties. And then on the right, you've got judicially enforced limits on congressional power and the administrative state, so that everyone is sort of using the courts not just for narrow legal rulings, but as a forum for policy. And that makes courts much more important than they were in the 19th century.
Thanks. I think that's really important. For some in the audience, Jamal, would you mind explaining just sort of how the court's discretion, how that has changed, and what kind of led to that switch in the judicial review power?
So I think it's a complicated story. In a lot of ways, the discretion that judges have is a function of the discretion that's inherent in our constitutional system, where you have a lot of vague constitutional standards, both in the realm of government powers and in the realm of rights after the 14th Amendment and the Reconstruction Amendments. But it wasn't until the 1960s where judges really, 1950s and 1960s, where judges really started to exercise that discretion, first in ways that I think are often associated with the left, with the Warren Court, but then subsequently the right has absolutely done the same when it comes to limits on congressional power, limits on the administrative state, are very robust First Amendment when it comes to commercial speech. And so now sort of everyone uses the courts very pervasively. We might think that's good or bad. I mean, there's a lot of things one can say about that, but there are ways of what it means is that you have people who wield an enormous amount of political power, but are in office for 2 or 3 decades, which we often don't think is appropriate in a democratic system.
Thanks. Okay, so to get back to some of the specifics on what we're talking about today, Gabe, hoping that you can give us an overview of some of the most common proposals for term limits. I know, of course, your organization has one of the most widely cited too. Oh, I think you might be on mute.
Yes. I think the most commonly, the most prevalent one out there today is an 18-year proposal where you have a new justice rotate onto the court, be appointed, nominated, and confirmed every 2 years. So that would be in non-election years, odd-numbered years. So if such a law passed or such an amendment passed tomorrow, you have a justice in 2021, 2023, 2025, et cetera. And it's this proposal is often called the regularization of Supreme Court term limits. So you just expect every 2 years, this is what we're going to do. And I mean, I think for the people who are skeptical of that, we actually did some focus groups on it about a year ago, and they're all up in arms about the contentiousness of the Kavanaugh hearing. But then they totally forgot that the Gorsuch hearing even happened. So the idea that and it was less than 2 years before that. So I think that once you get into a regular rhythm, you'd be sort of used to it. And then after 18 years, the justices would no longer be on the court. So a 2021 justice in 2039 would leave the bench and be replaced by a justice nominated in 2039, if we're going with that. And so at that point in time, there's sort of, this is where some of the proposals diverge. Would that justice become a senior justice and be able to come back on the court, say if there was the same issue with Scalia passing away, and we had, Justice Souter, Justice Stevens, Justice O'Connor at the time just sitting around doing nothing. Why couldn't they come back? So there's some proposals that would bring a justice back if there are fewer than 9 justices. Other proposals would just keep things the way it is, where if you're done after 18 years, you can rotate down to a lower court, which about half the justices, as you wrote in your report, have done since the advent of senior status, really in 1937 is when it was cemented. So that's the general outline, and there are different ways of getting out there. Statute amendment, we'll talk about that. But some of the other proposals out there are one that was talked about during the campaign is that basically every appellate judge in the country becomes a Supreme Court justice, and the Supreme Court would maintain its 2 weeks hearing cases, and during that 2-week setting, it would be a lottery court. So of the however many appellate justices there are judges there are in the country, I think about 189, all of them would be on SCOTUS, and then you just pick 9 random ones to hear cases over a 2-week period. Another idea is expanding the size of the court. There's several ways to do that. Generally thought of, you can do it by statute, but nothing is stopping us from having 11, 13, 15 justices. And even some of the 18-year term limits proposals would have a larger court, right? If you are adding justices in the Fix the Court proposal in 2021, okay, so you got a 10th justice. Well, that proposal doesn't say that RBG is going to be, I guess, it would make sense to be her, that she's got to go. So RBG could theoretically be the 10th justice in any 18-year term limits proposal. Maybe not in an amendment situation, but possibly in an amendment, maybe not in statute, or definitely very likely in a statute. So obviously, court, it's been called court packing. I don't love that term because it's super political, and what's not to say that other things in this world are court packing, but adding justice is a proposal. And then another proposal that was very popular during the campaign that we had that recently wrapped up was a proposal to have some sort of 5-5-5 plan, to harken back to sort of the late Herman Cain with his 9-9-9 plan. But it was a 5-5-5 plan with 5 Republican justices, 5 Democratic justices, and then 5 justices that the other 10 would pick. So that then you have 15 justices. So there are definitely views on, and there are other proposals too, by the way. In May of 1954, the Senate passed a resolution with a wide majority that would have limited the justices to 75 years. They would have to retire after they reached their 75th birthday. Senator Kennedy, Senator Johnson, I think Senator Goldwater was on it. Resolution was dropped because, in part because Brown v. Board came out the following week. But there have been throughout history some proposals to actually do a mandatory retirement age as opposed to a term limit. But that's just a general outline, and they don't. None of this really has a partisan balance. Is the other thing I'd like to say. You know, the person who I'd say is probably the most responsible for making the 18-year term limit popular is Steve Calabrese, who I think is a Republican, maybe up until last week, I don't know, but co-founded the Federalist Society, and him and this other Northwestern law professor, James Lindgren, wrote a seminal paper called Term Limits Reconsidered or something like that in 2006. And that's been really the most, a lot of people sort of get their history and their stats from that paper, and a paper by David Garrow on the superannuation of the justices. So, you know, and Garrow's an avowed liberal, Calabrese's an avowed conservative. So they're really just, over time, there hasn't been a partisan valence on this, except that, you know, in 2016, when it looked like Hillary was going to win, you had, you know, Marco Rubio and Ted Cruz and Ben Carson and Rand Paul saying term limits are great. Now in 2020, when it looks like Joe Biden's going to win, you know, the Republicans have retreated from that position. So but overall, in terms of just an ideological, like where it comes from, it's pretty down the center.
Great, thank you. And I think, like you said, the most common does seem to be the staggered 18 years with the current number on the court that we see bouncing around, as you said, from the across the ideological spectrum. Great, thank you. Jamal, I actually think if you wouldn't mind, this actually could be a helpful time just to let the audience kind of perhaps better understand just how unique lifetime tenure is for the Supreme Court, both when it comes to jurisdictions here at home as well as abroad, if you just wouldn't mind speaking to that.
Sure, it's highly unusual. In fact, I'm not aware of another country in the world that has lifetime tenure for its constitutional judges. There may be some. I'm pretty sure there are none in any Western democracies, and so that's instructive. When we look at the state systems, I believe only Rhode Island has life tenure for its highest court judges. So every other state has a limited term or has a retirement age, and that's the general trend around the world. Is either you have a term limit, and usually it's shorter than 18 years for most constitutional courts around the world, but you have a term limit, or you have a retirement age, or you have both. Where it's one or the other, and so that makes the U.S. quite unique in that sense, in that it's the only country that thinks that this is I don't think we even think it's that important. I think most people just accept it and just sort of take it for granted since we've had it for so long, and it doesn't really reflect anything about judicial independence. It's not as if the states of the union or countries around the world don't have independent judges. It's really just a holdover from a very, very different time when Article 3 was constructed more than 200 years ago. And I think it's really time for it to be reconsidered.
Great, thanks. And just to cut in for a second, for all of our viewers, just a reminder that we'll be answering questions towards the end of the event. So please feel free to submit those using, again, your questions tab on the corner of your screen or on Twitter at #SCOTUSTermLimits. And just another reminder for folks who are just joining us, if you need live captioning, it's available at americanprogress.org/live captioning. But okay, continuing on. Some of the reasons in support of term limits have already been raised, and I'm thinking it could be helpful to sort of dig into some of those reasons. So Caroline, I'm wondering if you wouldn't mind fleshing out the arguments around how staggered limits could help ensure the court isn't widely out of balance with the general public. I know you spoke to this in passing when you were in your first answer.
Great. Well, thanks. And thank you, by the way, and thanks to Kat for hosting what I think is a very, very important discussion. So there are a number of things. I think going back to the law review article that Gabe mentioned, the Steve Calabrese article, and I'm feeling more and more that I can see eye to eye with Steve Calabrese as time goes by. But certainly on this topic, what they did in that article, which I think is really useful for people to look at, is just an analysis of the length of service and the progressive increase in the number of years that justices serve. And the data is really exceptionally obvious. It makes it so clear how different this court is now from the way it used to be. The service on the Supreme Court was not a career. It was the capstone of a career. It was the culmination of a successful life doing something else, perhaps being a judge, but perhaps being a governor, such as of the state of California, or doing a whole variety of things. But it meant that the service was in fact typically less than the 18 years we're talking about. But then, it's been in very recent years that all of a sudden the service has stretched out to, often 30 plus years. And that means that a justice who was confirmed, a generation ago, and I bet there are a lot of people watching this program right now who have not been alive nearly as long as many of our justices have been on the Supreme Court now. And to think about that, and to think about the fact that the viewpoints that they were embracing, their view of the Constitution is one that was uppermost at a time when they were confirmed, I think it's just a reason to be really questioning of the idea that we have this the system that, as Jamal said, is unique in the world, that the idea that justices serve as long as they wish, and which has become decade upon decade upon decade. And so one of the interests is simply having a court that is more reflective of the current day, and not of a generation ago or two generations. But the other, and Gabe sort of talked about this to some extent, is that the regularization of the process of selection would diminish some of the outrageous partisanship that has been occurring. And Jamal also spoke of this around the Garland nomination, around Kavanaugh, the way the interaction between the parties, the interaction, the way that the Scalia vacancy was treated by the Republicans, by Mitch McConnell, preventing President Obama's nominee from even having a hearing. The idea that it gets regularized, every president gets 2 appointments, takes a lot of the burden of partisanship out of that process. It enables everybody to know that there is a process of selection that is outside of normal partisan stakes that have occurred, that have made it so incredibly important, because the cases are so far-reaching now, because they touch on so many aspects of our lives, and the way the selection process works, that there is the partisanship is ramped up to such a degree that certainly for some, the selection of a Supreme Court justice is the major reason to vote for president, and driving force in our politics. And that just seems wrong. And the court should be above the partisanship. The court should be a body that we look to when there are major questions about our Constitution, statutory interpretation, and we shouldn't have a suspicion that the justices are making decisions based on the partisan alignments that they might have. And right now, I think a lot of people feel that way because the selection process has become so bitter, has become so political, and that because they know that a justice once selected may go on and serve for 40 years. And so their view of a particular question under the Constitution, even if unrepresentative, even if out of sync with what most constitutional scholars, let alone most Americans, think, is likely to bind us for decades to come.
Thanks. I think that's really helpful. I think another thing that you were getting at is, in addition to generational divides, Gabe, I think your organization has actually done work on this as well, but it could help also increase, because we know diversity on our courts is sorely lacking. And we've seen some improvement, but hopefully we could also lead to there are more regular vacancies, more diversity on the court, both in terms of gender, race, and ethnicity, as well as professional diversity. And Gabe, I think Fix the Court has looked into that a little bit, if you wouldn't mind speaking to that.
Yeah, sure. I mean, studies have shown that if we keep on the current path in the next century, there are only going to be about 25 new Supreme Court justices. And under term limits, where you have a new justice being added to the court every 2 years, as we've spoken about, you have twice that, about 50 Supreme Court justices. And with more justices over time, it just increases the chances that it's not just a bunch of white dudes who were prosecutors and worked and went to Harvard. Having more picks means that it's more likely that the court looks more like the rest of America. I think that's a positive thing, no matter where you are on the political spectrum.
Yeah, absolutely. And so, Jamal, just want to make sure, I know Caroline touched on this about how regularity could diffuse the political nature of confirmation hearings, and just didn't know if you had anything to add on that point, given, I know you've written on specifically on that subject before.
Yeah, so I think I might be slightly less sanguine than some who support court packing about the ability of not court packing, of term limits, excuse me, of the ability of term limits to depoliticize entirely the process. And I don't think it should be entirely depoliticized. Some politics is quite important, but I do think I quite agree with Caroline that regularizing appointments is really important to making sure that the political process and people in the political process are aware that, okay, here's how many justices this particular president's going to have. This is how many the next president's going to have. And so there's less uncertainty. I also think, and consistent with what Gabe just said about diversity, is when you do some depoliticizing of the confirmation process, and when you know someone's only going to sit for 18 years, that affects the nature of and the quality of the nominees you look for. You don't necessarily have to find someone who's 25 years old and seed them for the court so they can sit on the court for 50 years. You don't need to necessarily, or at least the stakes are lower in finding someone who has no paper trail, right? So someone who's been hiding in some government office or hiding in some corporate firm. You have a little bit more flexibility to pick people because the stakes are different, to pick people who have a wider array of backgrounds. You can also pick people who are slightly older, who have distinguished themselves at various points in their career. It shouldn't be the case that someone who's 60 years old is and has had a long distinguished career making high quality judgments in some contexts it can't be a candidate for the court because they won't sit on the court for 50 years, right? So I really think that it would make an appreciable difference in the process. Would it solve all our problems? No, but it would mitigate them, and it would. I think just stepping back from the practical details, just the idea that someone in a democratic system should wield that amount of power for that long, and also decide, essentially what the ideology of their replacement is going to be, just to be frank, is just ridiculous in a democratic system, and we should do something about it.
Great, thank you all so much. We have a lot of questions coming in, so hoping just to tackle one last subject before we turn to those, and it's an important one. A big part of this debate is how and if term limits could be enacted through legislation as opposed to a constitutional amendment. Gabe, I know Fix the Court addresses this specifically in the bipartisan proposal you've put out. And Jamal, I'm hoping maybe you could break down just some of the constitutional language at issue here. But first, just hoping, Caroline, if it might be helpful for the audience, if you could just give a brief primer on Congress's role in regard to the judiciary. I think a lot of times, besides the nomination and confirmation process, people understandably and rightfully think of them as very separate, but Congress has had a hand in the organization of the federal bench basically from the get-go, right?
Absolutely. I think it's a very important clarification. There's very little in the Constitution about the courts, really, except for the setting up the service during good behavior. Pretty much, there's almost nothing else. Congress is responsible for setting most of the jurisdictions of the courts, determining the number of judges. Early on, the Congress passed the Judiciary Act, which laid out how the courts would be structured. And in fact, quite recently, I think it was in 2009, and Gabe can correct me if I'm wrong, there was a bipartisan group of law professors that promoted a new Judiciary Act, which included an 18-year term limit proposal. It was a bipartisan group of law professors who believe that this can be achieved through a statute. Although Jamal's going to get into the constitutionality of that and how do you deal with the good behavior language. But essentially, there were a number of other provisions in that proposed statute dealing with how the courts are laid out. And most recently, or not most recently, but recently, Steve Calabresi, who's been mentioned before, made a proposal for President Trump to radically expand the current judiciary by adding a huge number of judgeships to take advantage of the speed and success with which President Trump has been able to, speaking of packing the courts, pack the courts with a group of very ideological nominees. And nobody suggested that his idea was unconstitutional, because clearly it's within the scope of Congress's powers to determine how many judges serve and what the structure of the circuits is and how many district courts there are and so forth. And they have an enormous amount of power to describe and define the role of judges and justices.
Great, thank you. And Jamal, hoping that you can explain sort of the language at issue here when, as Caroline mentioned, the service during good behavior protection that federal judges enjoy.
Sure, and there's really not much to it other than what you've just said and what Caroline just said, is that there's no more language in the Constitution about the terms of the Supreme Court other than holding office during good behavior. I think what's important to mention about this is a couple of things. So one is that there are circuits, courts of appeals that require judges to go senior at a certain point in their tenure, and so moving from regular active status to senior status has not historically been understood to be a violation of good behavior. So you still hold your judicial office, you still get paid, but you hear fewer cases, or your docket changes slightly. And Supreme Court justices themselves have, of course, after sitting down, have sat on other courts. So to my mind, and I don't think it's an obvious constitutional question, I don't think the answer is obvious, but to my mind, the argument for saying that good behavior is consistent with redesignating Supreme Court justice to other courts has a strong foundation to it. The other point I'll make is that it's not obvious historically that good behavior is violated by a term limit. What it's really trying to get at, the purpose behind having the good behavior provision, is that political actors should not be deciding based on the court's decisions or based on the actions of the judges what the length of their term is. So they shouldn't be able to say, okay, I didn't like that decision, so you're fired. But that's not what a term limit is. A term limit could very well say, look, you can't be replaced during this period unless you're impeached. You can't be replaced during this time period, and that serves the function of the good behavior provision quite adequately.
Maggie, you're muted.
Sorry about that. I said something very brilliant, so I hope I can restate it. No, but before I turn it over to Gabe for our last question, just as a reminder, what it seems like a lot of our participants are already well aware of, we'll be taking questions shortly, so please submit any that you have for our panel using the questions tab at the side of your screen, or again through Twitter at #SCOTUSTermLimits. But before we do wrap up and go into questions, I just really wanted to turn back to you, Gabe. Given your organization's work specifically on this, on the statutory question, just wanted to make sure to give you an opportunity to detail anything about your approach or anything to add.
Sure. So I mean, the statutory approach has been spoken about for close to 20 years, but it has yet to be tried. There has yet to be a bill introduced in Congress that said, by statute, after 18 years, new justices, prospective justices would rotate off or rotate back. Over the last 200 years, there have been draft amendments, draft resolutions, amendment introductions, all that. Really stopped about 20 years ago. It was mostly on right, actually, but trying to limit term limits is more of a creature of the right, I think, than the left. But even since this sort of broad-based movement across the ideological spectrum from the legal community supporting an end-to-life tenure, there hasn't been any statutory language introduced, and there actually hasn't been an amendment introduced saying, okay, 18 years, we're going to rotate. It's just like, I think justices should only serve 12 years, and like that amendment has been introduced like 100 times over the last. It hasn't been introduced in the last 20 years, but it had been introduced like 100 times in the 20th century. So I mean, our idea is very simple. It's prospective, add a new justice every 2 years. The current 9 can do whatever they want. They can stay on, they can leave. We give them the option. So, when you game this out, if every justice leaves after about 27 years, which is the going rate now, if the current 9 do, it would take 20 or 30 years to get to a perfect rotation of, 9 justices, 18 years, right? So you'd have, so it's possible that the 2021 justice would retire in 2039, but Justice Gorsuch is still on the court in 2039. So it's not, look, none of these are perfect, but I do think that one of the things that I guess has been a little bit, disappointing is that there has been talk about this in the presidential race since at least 2012. I mean, Rick Perry came out with an 18-year term limits proposal when he ran for president in 2012. A lot of the folks on the left and the right did in 2016, and then obviously on the left in 2020. And our thinking is that, we have, Fix the Court has its proposal, we're doing our work on Capitol Hill, but we really think that it would be interesting and instructive to see 6 different term limits proposals. Let's have a 20-year proposal, a 15-year proposal, an amendment, a law, any sorts of, all the different combinations and permutations that you could possibly think of, the Dan Epps and Guinness phenomenon. Every appellate judge is a SCOTUS justice, the 555 plan. All of that out there, all of that in statutory language, all of that vetted through the House or through the Senate lawyers, and have those introductions, to have those conversations, because for the vast majority of the conversation that has focused in the last year about this, it has been very much theoretical, and I think we've reached the point where we really need to put meat on the bones. We need to put pen to paper. We need to say, look, I mean, in our Fix the Court's proposal from 2016, we don't necessarily, it has this whole thing about what to do for a chief justice. That unnecessarily complicates things. So we're throwing it out and moving in a little bit of a different direction for our latest proposal. But the point is that, given that, the legal academy is, 2 law professors, 3 opinions, a lot of, I think what we're aiming for is to have sort of a broad-based coalition and to have a bunch of different proposals out there. So, we like our 18-year statute. Some people might like an 18-year amendment. Some people might like something else. Some people might like expanding the court to 27 justices. Who knows? But we really want to get to the point where we're pen to paper, we're introducing things now, because the other thing is too is that if you have a crisis at the Supreme Court, if something happens where 3 justices die at some point in their 90s or 3 justices become senile, or there are all these different things that could possibly happen when you have a superannuated bench. We want to be sure that we have the language and the process set, because clearly what happened in 2016 with Scalia was not tenable. So we need to do better, and I think having a set of proposals out there fully hashed out is where we need to go.
Great, thank you. So I think we're ready for questions, and everyone watching, please have patience as I navigate reading these off for everyone. You know, this can be a general question for each of you, or rather anyone interested in speaking of, you know, we see a lot of support for just the idea of term limits, even if it's not wedded down to one specific proposal. What do you think is needed to do to continue that momentum, especially when it comes to Congress?
Sorry, is that momentum with term limits for members of Congress, or the momentum of the statute, of pushing a statute in Congress for Supreme Court term limits?
Yeah, momentum of pushing the statute.
Oh,
how do we get there? How do we keep the ball rolling?
Well, I think I was heartened that there was some discussion among the at least the Democratic candidates and prior years among Republican candidates. There could have been a lot more. I think perhaps there has been a heightened understanding in the last number of years among progressives that the courts are not an afterthought, that they are a central element of what they should be concerned about. And I think recognizing that the court's politicization, particularly now with the very ideological judges who've been put on the court by President Trump, I think hopefully we'll get people to engage more, and an engagement would allow them to listen to the proposals regarding term limits, which I think, you know, generally people like the idea. I mean, I think the polling shows there's sort of openness among Americans. Term limits are kind of seem like a good idea. There's just not a lot of passion around it, I think, at this moment. But I think honing in on the incredible power of the courts, this shouldn't be partisan. It really is an increase in authority and reach of the courts generally, but the Supreme Court particularly, that is, I think, very difficult to equate with a democracy where we, the people, are supposed to be making these central decisions. And I think we need to capitalize on that. We need to capitalize on this moment. But I think it's going to take people really focusing. Courts broadly matter, and the Supreme Court matters at this point most of all.
I think it's going to take looking outside the judiciary committees. If we're serious about this, I know there's some congressional staff on here who are probably not going to like it, so I'm talking about their bosses, but we're serious about this. There is no chance in hell that a member of Congress who has been a member of Congress, either in the House or the Senate, for 30 years, for 35 years, for 40 years, is going to introduce this bill. It's just not going to happen. So, you know, Chuck Grassley, Pat Leahy, Dianne Feinstein, Jerry Nadler, these aren't going to be your champions. And I think it's important to realize that you're going to have to look outside the judiciary committees, maybe the oversight committees, maybe, you know, some sort of, not the problem solvers caucus per se, because I don't know what the hell they do, but, you know, some like freshman members that are a little bit more about, you know, trying to fix the institution of Congress, not necessarily in an iconoclastic way, but just, you know, are able to work across the aisle to achieve solutions. Those types of members. But I think, you know, one of the, just, you know, as someone who has been in 100 Hill meetings about this, one of the biggest challenges is pitching this to someone who's been on the Hill or in Congress for 3 or 4 decades themselves, because they see it as a threat to their own job, livelihood, ethos, what have you. The other thing is that, I mean, I think the Senate in general is potentially a lost cause. This needs to start in the House. If you are the Senate, despite the fact that, you know, there are a bunch of people up there that you know, seem new and interesting and iconoclastic and thoughtful and all that, it's still pro-institutionalist, it's still slow, and it also has several members who themselves are former, this sort of ties to another thing, who themselves are former federal judicial clerks. So if you're a former law clerk at the Supreme Court, I don't know the term, but it's like reverse Stockholm syndrome, where you think that 1 year is the best year of your life if you're a former Supreme Court clerk, and you wouldn't want to change anything about it. And the idea that someone like me would come in here and try to change the way that the Supreme Court justices are appointed, or the way the Supreme Court acts or reacts, is a little bit anathema to you. So, which is not to say that being a former Supreme Court clerk isn't a great proving ground to one day become a senator. There's several senators on the left and the right who have that background. That being said, I feel like having that background, being a former federal law clerk, Supreme Court or otherwise, just also adds to this pro-institutionalist ethos, which to us has been a barrier in getting a term limits bill introduced.
Great. And I think, the increased conversation on the need for systemic change is an important one that we're seeing grow more and more across the board. I think we may have lost Gabe for a moment. But Jamal, I'm hoping just you could give some brief thoughts on some of the benefits that we've talked about, term limits, how important it would be to couple term limits with a regular, to a term appointment, as we look at some of the potential benefits of term limits that we expect.
So the regularization issue. Well, I guess the first thing I'll say is, as someone who clerked for a Supreme Court justice, and who was, I think at the time, in his 32nd term on the court, I can tell you that reform is possible, even from those quarters. And it's really, I think, to reemphasize that really, I think most people who think seriously and carefully about term limits see its benefits, however they come out ultimately, see that it has a lot going for it. And you look at the left and the right of this issue, and we mentioned Stephen Calabresi and Caroline Fredrickson on this call, 10 years as head of ACS and the founder of the Federalist Society agreeing on something. And it's not just them, but it's Frank Easterbrook, and it's Lawrence Silberman, and it's we're on a Center for American Progress call. I mean, this is a really broad coalition, as broad a coalition as you can find on any issue in American politics. So I hope that has a momentum on its own. In terms of regularization of the process, I think there's just far too much uncertainty when you're in a political environment where everything is what happened, what have you done for me lately, what happened yesterday, and if you're in a situation where life expectancies are what they are, Supreme Court justices have very comfortable lives, more comfortable than they once did. They don't ride circuit anymore. They have pretty good health care, and they live in nice houses and so forth. And so if someone's picked at 50 or 51, which is about the average age when a justice is picked, the idea that they'll be on the court for 40 years is not at all out of the question. And so that's some serious stakes, and serious stakes where because there are so few vacancies, you don't know if the next one's going to come up in this presidency or not. And so it makes sense. It makes political sense to arm yourself to the teeth. And it's just not healthy. And regularizing the process would, again, it wouldn't take the politics out of it, nor should it take the politics completely out of it. But it would at least make the politics normal. And that's part of the proposal that Gabe mentioned to make every Court of Appeals judge a Supreme Court justice, which I think is awesome, but pretty far-fetched. That's also about making the process more normal. There's going to be politics in picking Court of Appeals judges, but if it's completely diffuse, who are those people going to hold the power of a Supreme Court justice? That just makes it into normal politics, which is what we should be doing in a democratic system.
Great, and we are really close to time, but I figure I'll ask one last question, which is a fun one, and I suppose actually speaks directly to this broad coalition we're talking about supporting term limits, even among those who have certainly thrived within the system. Has there ever been a sitting Supreme Court justice who has spoken out in support of term limits?
Generally, I mean, we anytime we get a ping from SCOTUS map saying that a justice is going to appear at college X, we'll reach out to a student, or law school X, we'll reach out to a student or the professor who's doing the panel and being like, hey, can you please ask Justice Breyer or Justice Kagan or whoever about term limits, Justice Ginsburg, and they actually do a fair amount of time. So, in your report, you highlight Justice Breyer. He's been asked about term limits a couple times, thanks to some of our my staff doing that, and Justice Kagan as well. And they're familiar with this proposal. At least definitely a third of the current justices I know would be okay with an 18-year term. One or two have switched their views, and then I think the rest would be against. But like Roberts, obviously, being the most prevalent one, he was in favor of term limits, a 15-year term limit, which would be like now, when he was a Reagan administration attorney in the 80s, and now he's against it because he's concerned that the justices in year 16 or 17 would do something that would ingratiate themselves with a future employer, which of course is to say, like, that could absolutely be happening right now. So I think that argument that he's given at cocktail parties in DC doesn't hold much sway. But yeah, I think that the justices would be okay with it, especially ones that have had jobs outside the federal judiciary, right? If you've been, if you've set up your own shingle in private practice, like Sotomayor and Kennedy have, if you've been a law dean like Kagan have, if you've done things outside of the government, and most haven't, or Gorsuch was at Kellogg, Huber, whatever they're called, for like a few years, and other than that, he's been at DOJ, he's been at the 10th Circuit. Having sort of I think when you bring in what Jamal's point was earlier about diversity of experience, you're going to have justices that are a little bit more in touch with the pulse of American society, and the American society right now thinks it's ridiculous that justices are serving for 30 or 35 years. So right now we've got 3-ish that I think would be in favor, but as time goes on, I think that number's going to increase.
Great. Well, we are right at time. I just want to thank everyone again for joining us, both who have participated, and of course our panelists for lending your morning to us. A copy of the report we released yesterday is available at americanprogress.org, and a closed caption enabled recording of this event will be available this afternoon at americanprogress.org/events. Please don't hesitate to reach out with any further questions or follow-up. And I hope everyone has a good rest of the day. And for those in DC and the East Coast, please watch out for the weather and stay safe. Thank you.
Thank you, guys.